Welcome everyone. My name is Jennifer Hill. I'm Professor of Corporate and Commercial Law, the Bob Bax Chair at Monash Law School, and it's my great pleasure to welcome you all to this seminar of the Commercial Law Centre today at Monash Law School. We're going to get started in about a minute, and I will then be introducing you to our speakers as everyone is let into the seminar. So I think we will get started at this point as people are coming into the seminar. Thank you so much for coming to today's seminar. It is the first of our seminars in the 2021 Law and Business Seminar Series at the Commercial Law and Regulatory Studies Centre, or CLARS as we call it, at Monash Law School. And we're very fortunate to have as our first speaker today, Professor Randall Thomas from Vanderbilt Law School in the US. So welcome, Professor Thomas, from, I think it's afternoon for you, morning for us here in Australia. Professor Thomas is the John S. Beasley, the second chair in Law and Business and director of the Law and Business program at Monash Law School. He is also a research member of the European Corporate Governance Institute. He is a prolific author in the field of corporate law and comparative corporate governance. He writes in the areas of shareholder activism, corporate and securities litigation, executive compensation, corporate voting, and corporate governance. Today, he is going to be speaking to us on the topic resisting the return to managerialism, institutionalizing the shareholder voice in the monitoring model. And we are equally fortunate to have as our commentator someone who knows all about this, and that is Iris Davila. Iris is the director and she's head of BlackRock Investment Stewardship Team in Australia, and she's responsible for engagement and proxy voting activities in relation to Australian and New Zealand companies. Iris began her career working for BlackRock in their New York office in 1998. She then moved to Scotland, and then we were fortunate enough to have her come to Australia as BlackRock's first representative in this region. She is a graduate of Princeton University, where we just discovered Professor Thomas grew up. So I'm going to pass over now to Professor Thomas, and thanks so much for being with us, and over to you. Oh, I have one thing I should have said, which is after they speak, Professor Thomas will speak for around 30 minutes. Iris is going to speak for 10 minutes. We will have time for Q&A, and if anybody has questions for the speakers or comments, please put them in the Q&A box. Please also identify yourself, and I'll be reading out those questions. And now we can take it away with you, Randall. Thank you.
All right, well, thank you very much, Jennifer, and thanks to Monash University. Contrary to reports that you may have heard, I am not a professor at Monash University. I'm actually at Vanderbilt Law School. I want to take a moment and just thank Professor Hill in particular for having me out. It's fabulous news for Monash that you now have Jennifer on your faculty, and you should be thrilled to have her there. I wish I could be with you, but unfortunately I'm going to be virtual today. So I wanted to put up some slides, so I'm going to go ahead and do that if you bear with me for a moment. Okay, so the title of this paper is Resisting the Return to Managerialism. And as you'll see, what the paper is about is what I'll call the director monitoring model. And the director monitoring model is something that we teach in our basic corporations class. Oops. Sorry about this. Okay. At the beginning of every corporations class, in the beginning of term, one of the key questions that we ask is, what do we want corporate boards to do? What do we want corporate directors to be doing with themselves? And the thesis of this article is that effective director monitoring of corporate management is essential to good corporate governance and the basis for what we'll call the director monitoring model. And by monitoring, I mean basically keeping an eye on what management's doing, making sure that we take steps to improve value in the company. Now, this model was developed historically in the 1970s at a time when shareholders were weak. And therefore, it didn't really emphasize the importance of shareholder voice as part of monitoring. The full effectiveness of monitoring efforts of independent directors, though, requires that shareholders have a voice and that voice be potent. So that's the main thesis of the paper. And now towards the end of the paper, I'll talk about a couple of other things. Recent proposals that have been made by, among others, the Wachtell Lipton law firm in New York that prescribe what's called the new paradigm, which is, you'll see, is a version of what I'll call stakeholderism. And these are important policy developments in the US scene. And I should add, this is a fairly US-centric paper, and I'm happy to try to I'll try to describe the institutional features of the US market, but there will be some things that are unique to the US. So we'll see how those relate when Iris talks about Australia. So these stakeholderism and the new paradigm, our thesis is they weaken the shareholder's voice and thereby undermine the director monitoring model. So I want to start with a little history and begin with the post-World War II period. And an important feature of the US economy at this time was that the US firms had big economic advantages over international competitors, in large part because they didn't have to rebuild war-damaged industries. So as a result, they were in a situation where they generated a lot of economic rents. In other words, they were flush with cash. And during this time period, American corporations were run by powerful CEOs, purportedly for the benefit of the stakeholders of the company. Stockholders at that time were retail investors. They were dispersed, they were weak, and they were ignored. Most corporate boards were comprised primarily of insiders, while many of the rest of the directors were friends of the CEO. And the CEO controlled the nomination process. So the CEO pretty much determined who was on the board. Manager's role was to be responsible for balancing stakeholder claims on the company and assigning to each stakeholder a portion of the firm's income stream on the basis of some type of idea of public policy. Now, managerialism had some negative features, and I want to focus a little bit on those before we move on. It generally led, though, to strong CEOs and weak directors. And the problem, one of the big problems with managerialism was there was a lack of accountability. The stakeholder-oriented model led to companies where CEOs were not accountable to any one group. At the time, director involvement in monitoring management was minimal. If in a study of boardroom practices, Professor Miles Mace of Harvard University found that part-time directors did not devote much time to the companies whose boards they served on, and that boards had too many insiders to be considered to be independent of the CEO. Dissatisfied shareholders had little recourse. They were on par with the other groups that had claims on the firm, and their influence was minimal. So there was little shareholder pressure on directors to monitor the CEO of the company. If you were dissatisfied with corporate management, you followed what we call the Wall Street rule. That is to say, you sell your stock rather than to try and engage in bringing about change at the company. Now, the weaknesses of the managerialist governance system led to its collapse in the 1970s and 80s. And part of the pressure was from rising international competition from companies and from countries in once war-torn areas, from companies in once war-torn countries. It was also plagued by an inefficient form of organization called the conglomerate, and there were widespread bribery scandals, at least in the US market. Pressure from hostile takeovers also contributed to the demise of the managerialist system and helped bring about a sharper focus on shareholder returns, as this external corporate governance mechanism had an impact across the economy. But what really brought about change was the growing holdings of institutional investors as they became more and more important. This led to the rise of the monitoring model. Now, the monitoring model was largely developed by a series of academics, and it was based on the belief that independent directors can act as robust monitors of corporate management to improve corporate performance and, when necessary, take action to terminate ineffective corporate managers. During the 1970s and 80s, many companies embraced the monitoring model, and there was a shift towards independent directors as constituting a majority of the board. Increasingly, the focus was on investors, and managers tried to maximize share price, specifically to maximize returns to shareholders. But at the time of this initial embrace, the monitoring model was both incomplete and board-centric. So let me explain what I mean by that. The idea of incompleteness is that directors didn't have all the things they needed to do their job. So it was incomplete in the sense that we had part-time directors who had limited access to information that was selected for them by the CEO of the company. The director nomination process was dominated by corporate management, so the independent directors were often still not so independent. And finally, the independent directors had limited financial incentives to improve corporate value. They were not generally compensated in stock. Board centricity arose because at that time, shareholders were still often too dispersed to organize effectively. Thus, the original form of the monitoring model did not include much of a role for active shareholder monitoring as a method of encouraging more effective director monitoring. So that's a key point to notice here, is that we're talking about how shareholders impact directors monitoring. Now, as institutional investor grew and began to become active, that had an impact on the monitoring model. And in particular, potential for shareholder monitoring to boost independent director monitoring was growing. By the late 1980s and expanding into the 1990s, institutional investors' stock ownership increased dramatically, and the barriers to effective shareholder activism weakened. Shareholder activists' initial focus was on governance proposals that related to, among other things, stronger board independence, annual elections, and direct shareholder nominations of directors. Now, if you're following along, you'll know that these initiatives targeted the weaknesses of corporate boards, and in particular, the board-centric nature and the incompleteness of the monitoring model of what directors do at the corporation. But the promise of institutional investor activism remained in many places still a promise, as it was limited by legal rules and financial considerations, as well as time constraints on the institutions and their staffs. These problems facing institutional investor activism were only slowly addressed in the 1990s. So, for example, we saw the advent of third-party voting advisors, such as ISS and Glass Lewis, that grew up to assist institutions in deciding how to vote their shares and to provide them information about the companies they held stock in for purposes of shareholder voting. We saw government regulators requiring institutions to vote their shares to maximize the value of their portfolio. So the Department of Labor issued regulations imposing this requirement on institutional investors. And then some of the proxy rules that had created legal barriers to institutional investor coordination were relaxed. So overall, there was a shift away from regulation of institutional investors to permit them to have greater freedom to interact with each other and impact the board. So during this time period, shareholder engagement with directors started to impact the board centricity of the monitoring model as directors engaged in more monitoring of corporate management at the behest of shareholders. But the promise of institutional investor activism as a solution to the weaknesses of the monitoring model still remain largely a promise. There was a gap in our corporate governance system, and this gap set the stage for the emergence of a stronger form of institutional investor activism, activist hedge funds. These activist hedge funds really took off in the early 2000s and have become a very important feature of the US market since the mid-2000s. And today they're ubiquitous. Today you can't pick up the Wall Street Journal without hearing about some activist hedge fund investing in some targeted company. Activist hedge funds entered as what has been termed governance intermediaries. That is to say, investors who target companies for interventions at low cost to institutional investors. And the key point to remember about these hedge funds is while they hold significant stock holdings in the companies they target, they are largely dependent on the support of institutional investors in order to bring about change and to complete their program of change for the companies that they're targeting. Now, there's an enormous amount of controversy over hedge funds in the US. It's clear from the empirical evidence that they did create at least short-term gains, and then perhaps more controversial long-term benefits as well. And the latter part is the part that's controversial. There's research on both sides of that question. But the reason hedge funds are important for my thesis in this paper is that hedge funds help solve the incompleteness of the monitoring model. Directors, even when truly independent, suffer acute time, information, talent, and psychological constraints that limit their ability to fully assess strategies pursued by firm management. Activist hedge funds, at least in the US, often provide directors of targeted firms with alternative business strategies backed up by investment banker analyses and reports from top-notch business consultants. And the key point here for our thesis is that these are important alternative information flows that help resolve the monitoring model's incompleteness. Hedge fund activism also impacts the board-centric nature of the monitoring model. And it does so in a variety of ways, but what I want to focus on are when a hedge fund intervenes and the company agrees to what's called a settlement. Typically in these settlements, both parties agree to drop whatever litigation they have against each other. And typically the hedge fund will receive the ability to put some directors, 1, 2, 3 directors on the board of the targeted company. Now, these new directors see monitoring of corporate management as one of their most important functions. And they view themselves as more effective monitors when supported by other shareholders, thereby addressing the original board-centric aspect of the monitoring model. Remember that original monitoring model did not include much of a space for shareholders. Now we see shareholders becoming a very important part of the director monitoring model. By all relevant measures, the impact of hedge fund activism has been very widespread in the US. So this is bringing about real change in our economy, and in particular, helping fulfill the director monitoring model's promise. So the story so far is that we have the rise of financial institutions, the emergence of third-party voting advisors, and the appearance of hedge fund activism, and that all of this has gone towards solving the collective action problem that hampers shareholders' roles in the monitoring model. But that is not the end of the story. Not surprisingly, opponents of strong director monitoring have pushed for change to US legal rules to weaken shareholder monitoring, weaken shareholders' voice, and undermine the monitoring model. And in the paper, we discussed a number of them. In the interest of time, I'm just going to focus on one today. And that is the attack on third-party voting advisors. As you may recall, third-party voting advisors have a role to play in voting in that they help shareholders solve the collective action problem. That role is very much tied up in their regulation by the SEC. And in recent years, the SEC has taken the approach of trying to reduce the importance of third-party voting advisors and to make it more difficult for institutional investors to rely on their information that they're provided. So in 2018, the SEC's Division of Investment Management withdrew its no action guidance that allowed institutional investors to rely on proxy advisory recommendations when voting their shares. This was followed in 2020 by the SEC approving amendments to its rules governing proxy voting advice that, among other things, expanded the circumstances in which proxy voting advice would constitute a solicitation under federal law and thus be regulated. And by being regulated, that makes their job much more difficult. Further rule changes were made to require, among other things, that proxy voting advisors provide companies an opportunity to review and give feedback on proxy voting advice before it is given to their clients. So all of those are changes that have had the impact or will have the impact of hamstringing the proxy voting advisors and thereby making it more difficult for institutional investors to intelligently vote their shares and to organize in a collective manner. Okay, so let's get to the new paradigm. So management-centric advocates have proposed an alternative model of corporate governance that focuses on a concept they call long-run value, long-term value, and has a stakeholder-focused model of good governance. This is called the new paradigm. It was first proposed by Marty Lipton of the Wachtell Lipton law firm. Under the terms of the new paradigm, institutional investors are to take an active but measured role in supporting long-term investment. As part of this role, institutions are to develop firm objectives focused on long-term performance for each of their portfolio companies, as well as expertise and staffing necessary to formulate its own voting guidelines, communicate with corporations, and evaluate matters presented to a shareholder vote against these objectives. And that all sounds great, but this is going to be very burdensome to diversified investors who hold hundreds of stocks because the new paradigm rejects the use of proxy voting advisors as a tool for institutions to obtain information and to vote their shares. The new paradigm also doesn't weakens shareholder voice. If institutional investors follow its guidelines and in the course of doing so, conclude that a particular portfolio firm violates the fund's objectives, then the new paradigm calls on them to provide the corporation with prompt notice of its concerns and to invite the corporation to engage with the investor and work together towards the creation of sustainable long-term value. Again, that all sounds great, but in the end, institutional investors are invited to talk, but only to talk. And that's the extent of their leverage if they disagree with management. And to us, this seems inconsistent to ask institutions to invest heavily in engagement and then ask them not to act when their views are at odds with those of corporate management. Many institutions will not engage corporate management in the manner envisioned by the new paradigm or on the issues that it envisions, especially passive indexed investors whose business model does not reward substantial investment and engagement. Furthermore, existing engagement practices at actively managed financial institutions based on current rules are already quite extensive without needing to comply with the new paradigm's approach. And this good stewardship generates value for investors. In sum, the effectiveness of the monitoring model requires potency for the shareholder's voice, and the prescriptions that make up the new paradigm weaken the shareholder's voice. So there's a contradiction here from our perspective in that we've developed this director monitoring model in a way which finally empowers it to make a difference. And of course, once that happens, now we see efforts to chip away at it to weaken the shareholder's voice and to weaken the monitoring model. The second initiative that was brought forward by pro-management groups is the Business Roundtable statement that embraced the view that essentially stakeholders have primacy. In other words, that each of our stakeholders is essential, that they would lead their companies for the benefit of all the stakeholders. The Business Roundtable statement went on to state that financial metrics such as total shareholder returns and earnings will be balanced against a more holistic understanding of firm value. And a large number of US corporations signed on to the Business Roundtable statement. Now, interestingly, and perhaps a little bit cynically, New York Times reports that during the pandemic, many of the signatories of the Business Roundtable statement laid off workers and cut dividends, while executive pay was kept intact. So should we embrace stakeholderism? And in the paper, we talk about that idea. And what we focus on is that the US has already had this experience once. Back in the mid-1980s, in response to the hostile takeover wave, a large number of US states adopted what are called other constituency statutes. And the idea was that the board would be able to take into account the interests of all corporate stakeholders, oftentimes limited to resisting takeovers, but in some cases more broadly for a number of things. Now, these statutes were a mixed bag. They were inconsistent in how they defined stakeholders, some states including some types, other states including different types, and they often left it in the hands of the board to decide what the stakeholder interests, who the stakeholders were. In addition, the drafters of the Model Business Corporation Act during this time period rejected including another's constituency provision, finding to be inconsistent with managers being held accountable to anyone. And that is, I think, the big weakness of the stakeholder model, is that it's difficult to hold anyone accountable for anything. Professors Babchuk and Talarita criticized stakeholderism in their recent paper for a number of reasons. First of all, they point out that corporate management and directors' economic interests do not align very well with those of most stakeholders because they're compensated with equity-based pay packages. So they're aligned with shareholders, but not with stakeholders. And so one wonders why they would be taking action on behalf of stakeholders. Second, stakeholderism expands the freedom directors and managers have in decision-making, which insulates them from accountability to stakeholders and reduces shareholder monitoring. So this is a real problem. I mean, how do you figure out what stakeholders are entitled to what? There's no mechanism, there's no voting mechanism for stakeholders, and the information the board has will necessarily be incomplete. All right, so I'm going to wrap up and then turn the podium over to Iris. In conclusion, the monitoring model, the director monitoring model, was sensible when it was adopted, but the rise of financial institutions and hedge fund activisms were necessary to complete it. The full effectiveness of director monitoring efforts requires the potency of the shareholder's voice, though. That's our main theme in this paper. And the prescriptions of the new paradigm and stakeholderism weaken the shareholder's voice and thereby undermine the monitoring model. All right, so I'll take the slides down and turn the podium over. For those of you that are interested, there's some recent research out on short-termism claims. I just cited a few of the articles here. And Mark Rowe in particular has a book that's coming out, which I'm looking very much forward to. All right, thank you very much for your attention, and I look forward to your questions.
Thank you so much, Randall. Now, before I thank our speakers, I want to thank all of our audience for coming and saying we hope that we will see you at our next events. You will find in the chat box that Ellie in our events and marketing team has put up links to the next two events. We have one which is on the 3rd of March. That is the National Commercial Law Series, where Monash Law School is in collaboration with the Commercial Bar Association of Victoria, the Federal Court, the Victorian Bar, and that seminar conference is on reflections on the 10th anniversary of Competition and Consumer Act. And then we have on the 18th of February, so coming up earlier, we have the next seminar in this Law and Business seminar series, which will be given by Professor Elizabeth Pullman from University of Pennsylvania. She will be talking about startup failure, and Peter Dunn, who's a partner at Herbert Smith Freehills, will be the commentator for that seminar. So we would love to see you all there. But on all of your behalf, could I thank Professor Randall Thomas and Iris Davila for joining us today and giving up their time, both from America and Sydney. It's been fantastic to hear your paper, Randall. I don't think I've seen anyone cut through all those developments to show what's really going on as clearly as this paper does. So thank you very much for doing that. Iris, thank you very much for telling us how you operate in the real world through BlackRock. It's been a pleasure. Thank you.